So I will try to give an overview of Croatian legal system in regard of these plea agreements and position of fiscal authority and so on. And for some, since I'm dealing with criminal procedure, I have to say I'm not expert in these estimates and so on, so I didn't prepare all of the questions, but I'll do my best to present everything I know about the topic. So first of all, if we are speaking about the tax and customs authorities in criminal procedure, then and also misdemeanor procedure, we first have to say that these authorities, and we have two different authorities, one is tax authorities and the other one is customs authorities, they have a different role in regard to whether it is a criminal offense or is it a misdemeanor offense. And the difference between them is approximately, let's say, 2,700 euros in Croatian kunas, and also for the criminal offense, there needs to be an intent. So there's the difference between two of them. In misdemeanor procedure, tax and custom authorities are authorized prosecutor, but also the adjudicator in the first instance. So we have this so-called administrative criminal procedure in the first instance. And then if there is an appeal, then there is a high misdemeanor court in the second instance dealing with the misdemeanors. On the other hand, in criminal procedure, they can only file a crime report to the state attorney's office, who is in charge of who is a prosecutor in criminal procedure, and they can assist with the detection and the investigation of criminal offenses. In this regard, we have usually municipal courts dealing with the criminal offenses, and then county courts if there is any appeal. We had problems, just a second, in regard to ne bis in idem principle between the, let's say, misdemeanor proceedings and criminal proceedings, because earlier it was a practice first to conduct misdemeanor proceedings and then afterwards to have criminal proceedings. And we had some cases before the European Court of Human Rights, and it was established that it is actually a violation of ne bis in idem principle. After that, and it happened in 2011, 2012, there was a solution. They had some temporary instructions, and they said to the prosecutors that they had to choose one option, so to choose whether to go in criminal proceedings or in misdemeanor proceedings. Regarding the tax criminal proceedings, a small problem is that the prosecutors are not the same. As I said, tax authorities can be a prosecutor in misdemeanor, but not in a criminal procedure, so there could be some problems with it. The other solution that was brought is this Article 10 of Misdemeanor Act that actually gives the preference to the criminal procedure, and it says that if criminal procedure has commenced, the misdemeanor proceedings cannot be instituted, and if they were instituted, they have to be terminated. What happened in the meantime, there was a judgment of A and B versus Norway regarding these tax proceedings, and maybe we will have some changes because the new case law of the jurisprudence of the European Court of Human Rights has actually changed in regard to this ne bis in idem principle. When we speak about consensual procedures in criminal procedure, we had introductions of many different forms in the last 20 years. In theory, in Croatian theory, there is a conclusion that the legislator has not always been consistent with introducing new elements, not consistent regarding gravity of criminal offenses, the role of the court, victims' rights, and procedural and defense rights. Some of these procedures can also be used in tax and customs cases, and I will show you what can be used. First of all, we have some forms for less serious offenses, and these are the offenses with a sentence up to 5 years of imprisonment. In these cases, there is a possibility to use penal order, and there is also possibility of judgment in the case of a guilty plea at the trial. In addition to that, we also have judgment based on the agreement of the parties. It's Croatian form of plea agreement, and it can be used for all criminal offenses. And there is also possibility to use some other forms like crown witnesses and witness immunity in order to get the testimony of the witness or the accused, but I will not deal with them now. When you speak about penal order, maybe it's important to say it looks like German Strafbefehl. So in a way, you will know what it means. We can use it for criminal offenses punishable by fine or imprisonment of up to 5 years. And there are actually two preconditions. One is that the court agrees with the request of the state attorney, and the other one is also that the defendant tacitly agrees by not lodging an objection. If the objection is lodged, then we have a full trial. Important information from Croatian legal system is that in practice, in the last 5 years, from 37% up to 40% of all indictments contain a request for issuing penal order. So in practice, it's very, very widely used. Also for legal persons, in the last 5 years, it's between 22% and 34% of all indictments. One thing that we also establish in practice is that actually there is no informal plea bargaining before the issuing of penal order. So in a way, it's really a one-sided offer from the state attorney to the accused, and then there is a possibility to have a judgment. The other form is, as I already mentioned, this guilty plea at the trial. It's also a tacit agreement. It was introduced in 2002. It is also instrument for criminal offenses punishable by fine or imprisonment of up to 5 years. And it looks like this. So in the indictment for such crimes, the state attorney has to propose a certain type and measure of punishment to the court in the indictment, and it's obligatory. Then at the trial, if the accused pleaded guilty and agree with the proposed sanction, the court cannot impose another type or greater measure of punishment than the proposed one. So in a way, it's also some sort of agreement. And the last form that I want to say is judgment based on the agreement of the parties. It was first introduced in 2002, but it was just for the, let's say, crimes with the punishment up to 10 years. But in 2008, with the new Criminal Procedure Act, actually it was widened, and now it can be used for all criminal offenses. It is based on the statement of the parties on the agreement, and this agreement is actually submitted to the court. One of the peculiar things for Croatian legal system is actually that the court might refuse it only if it's not in accordance with the sentencing prescribed by law, or if agreement is not otherwise lawful. In practice, it is interpreted as that the court cannot reject the agreement if the court is not satisfied with the proposed sentence. So this case of accordance with the sentencing prescribed by law means only that it needs to be within the legal framework of sentence. Interesting thing actually is that in the misdemeanor proceedings, it's not like that. In misdemeanor proceedings, it's possible that the court rejects the agreement if it is detriment to the accused, or if it's not meet the purpose of punishment. So if the purpose of punishment will not be achieved in misdemeanor proceedings, the court can reject such a proposal. So in a conclusion, if we're speaking about the position of tax authorities, I can say that they have different roles in misdemeanor and criminal proceedings. if we speak about misdemeanor and criminal proceedings, there are many consensual forms that can be used for tax and customs related criminal offenses. Unfortunately, I don't have any data on the use of these forms in regard to tax offenses, unfortunately. And very big difference also regarding these plea agreements is in the position of the fiscal authorities, because in misdemeanor proceedings, they have the power to make agreement and decide whether there should be agreement or not. And in criminal proceedings, it is actually the decision of the state attorney. So in this regard, they don't have a power actually to influence, at least formally influence the agreement. So this is all what I had to say. So thank you very much for your attention. If you have any additional questions, I'm ready to give it to you.